All right. Hi, everyone. Please welcome Sandhya. Sandhya is a distinguished lawyer specializing in technology, media, and entertainment. Sandhya has worked with top firms like Amarchand and Mangaldas, Infosys, and Vice in Asia Pacific. In 2016, Sandhya founded Lexic, a boutique consultancy advising startups advocating for artist rights. She also hosts the Lexic Talk Music podcast. Sandhya has been featured in the World IP Review list of influential women in IP and the ALB India Super 50 Lawyers. Please join me in welcoming Sandhya for today's masterclass on understanding legalities as an artist. Over to you, Sandhya. Welcome.
Thank you so much, Rohan. And good evening, everyone. It's good to see this whole bunch of people here. It's been a while since I took a workshop, so excuse me if I'm a little rusty with talking. And I'm assuming that you have all come in because you want to understand a little more about how copyrights work with music and what royalties are, and as an artist, what are the things that you need to be looking at when you're kind of navigating this industry, right? Thank you so much for having me, Rohan, and to the team. And your description was a little elaborate. I mean, but I'm hoping that today's session is going to be interesting and useful for everyone. So feel free to take notes, and I'm available for questions by the end of the session, and we can also figure out if you have any doubts that I might not be able to clear in this next 1 hour. We can probably figure out a session later as well. Um, Honestly, this is something which I told Rohin as well, that 1 hour is actually quite less for the kind of topic that we're looking at. So I'm going to try and keep it simple and maybe not delve too much into details because typically the workshop that I conduct is like a 6 hour session. It's I'm split over 2 days because it's a lot of information. So I'm not going to waste too much more time. I'm going to dive right in. So I think it's important for us to set basics over here before we go into an actual discussion on how the industry works and what your questions are. So for example, starting off with the foundational question, right? What is a copyright? What does a copyright in music mean? And for you, as far as you are concerned as an artist, you need to keep in mind that a copyright in a song exists in two buckets. One is your underlying works, and one is the sound recording. When I mean underlying works, I mean the composition and the lyrics. These two aspects are extremely important to the copyright of a song. In fact, this is what actually constitutes publishing rights. And when I'm talking about composition, I mean the composition which you can actually sing. I know that from an artist perspective, it's kind of unfair when you think that a song is so much more than just the melody. I know you have the arrangement. I know you have so many components that form the composition, right? But as far as law is concerned, it is the primary melody of a song and the lyrics which actually constitute the basis of a copyright in a song. Now, the sound recording aspect is obviously a newer concept, right? Because back in the day, you did not have sound recordings, you just had the composition and the lyrics, and it was performed live. And the ownership of the sound recording, however, has a lot more value in today's industry than, based on how it has worked out, right? So your copyright in sound recording is referred to as master rights. So when we talk about ownership of master rights, it means your ownership of the actual sound recording itself. So now, this is going to be the backdrop for all our discussions today. When I refer to master rights, I refer to your ownership of the sound recording of your song. And when I refer to publishing rights, I'm referring to the ownership of the composition and the lyrics. Now, a copyright in a song is not just about the ownership. It's a whole host of things that comes with ownership, right? It's a bundle of rights. It's about your ability to distribute the song, to remake the song, to publicly perform the song, to give someone else the right to use the song for something, to remake the song, to remix the song. And each of these rights have its own value. And each right also has an ability to be licensed out. And the person who owns these rights is the one who has the right to license out these rights to. So, if you look at it, every royalty that you get is basically a license fee. It's an exchange for you giving permission to do something with your sound. That's a simplistic explanation for what a royalty is. A royalty is equivalent to a license fee. Now, what I mean by this is also going to be important for the next bit that we're going to be talking about, which is, I'm sure you would have heard about all of this: mechanical royalties, performance royalties, and sync royalties. Now, each of these royalties are connected to each aspect of your copyright. When I talk about performance royalties, it is the royalty that you are entitled to each time your song is performed. And when I'm saying song right now, I'm including everything, right? I'm talking about the composition, I'm talking about the lyrics, I'm talking about the sound recording as well. So, performance royalties are your most, in quotes, popular royalties that you've often heard about because it's also the most well represented, right? Um, the second one, mechanical royalties, is something that is actually limited only to the composition and the lyrics. You do not have mechanical royalties for sound recordings. The reason is the history behind it is that every time a composition or lyrics is reproduced, is mechanically reproduced, the person who did such reproduction was supposed to have paid a royalty fee to the person who owned the publishing rights. So the actual history behind it, I'll probably take like a minute on this, is that, of course, I mean, I'm sure you know that copyright is a European concept. It's not something, and which is also why it's kind of difficult navigating it in the Indian scenario, because how classical music works over here is a completely different, world. Um, so back in the day when compositions were created, you would have someone who would actually write it on sheet music and store it. Now, now, if someone else wanted to play my music and I have composed a particular melody, uh, and there is a middleman who comes to me and says that, listen, your music, everyone likes listening to you perform. Why don't you put it on sheet music? And for every sheet that you give me, I will pay you a certain amount. And for every sheet music that is sold to somebody else, I will pay you an additional amount. And for every performance that is played based on that sheet music, I will pay you a third amount. So each of these were royalties. And the reproduction royalty is what we call as a mechanical royalty. So, of course, I mean, in today's digital era, it has kind of evolved to a much more very, very different kind of, world, right? So you don't really have, everything is automated, and it's not like one person sitting over there, sitting and making sheets and licensing it out to people. I mean, you still do have one version of it, but every time your song is downloaded or your song is streamed, that is a reproduction. So that is technically, each time that happens, you are entitled to mechanical royalties. So your streaming revenue is actually split into two. It's split into your streaming revenue that you get from the sound recording itself, and the streaming revenue that you get from the reproduction of your composition and your lyrics. So you have mechanical royalties and performance royalties kind of merging under the whole umbrella term of streaming revenue in that particular category. You have performance royalties that accrue to you every time your song is performed somewhere, which means it could be in a mall, it could be in a bar, it could be at a concert venue. And each time your sound recording is being played, your composition and your lyrics are also being played. So you have performance royalties that accrue there as well. The third one, which I talked about, sync royalties, is something which is it's not automated, of course. It's very like person to person, individual to individual, corporate to corporate kind of transaction, where someone wants to use, if I want to use your song in my movie, I approach you and I tell you that I want a license to use it in the film, either as is or in a different, like maybe adapted better for the film. So each aspect, the sync as is, there's a sync license fee that is paid for that. For the other bit where you're remaking it for the web series or the film or whatever purpose that you're remaking it for, there is a different aspect, because the new product which comes, the remade product, is a derivative, right? So this is what I'm talking about when I say that ownership in a copyright is like a bundle of rights. You have multiple aspects to it. So my ability to remake a song is my exclusive right as the owner. And if I have to give that to you, you have to pay me a certain amount to do it. And that is where the whole concept of a royalty kicks in. I know this is we've discussed a lot about this. These are the basics, right? So just to kind of walk through that whole bit again. Master rights refer to ownership of sound recordings, and publishing rights refer to ownership of your underlying works, which is your composition and your lyrics. So when I'm referring to a song, I'm referring to all these three. I'm referring to the composition, I'm referring to the lyrics, I'm also referring to the sound recording. Now, there's a very important aspect over here, which was monetized only after 2012, right? Which is the performer's right. Now, the performer's right is basically the person who has performed on the song. So the person who has either played a instrument or sung the song are referred to as performers as per the Indian Copyright Act. Now, these performers till 2012 had a right to be acknowledged as the original performer. They didn't really make any money off it. So copyright, the whole concept of copyright is not just to give you the moral validation of having authored or having composed a track, but also for you to be able to economically benefit from it, right? So that's the whole, like the basis of copyright is that protecting your copyright and also monetizing your right, your composition, your works. And after 2012 in India, performers were allowed to collect royalties for their performances. So, which is why there was a copyright society formed for them called ISRA, which is now called ISAMRA. And that kind of leads me into the next bit, which is about copyright societies. So I'm going to take a pause here. I think I saw someone ask some question. Does anyone have any questions so far? Streaming revenues, 80% master sound recording plus. So the thing is, Anupam, I mean, this is actually a good question because this split is not uniform, by the way. So you can say it might largely be true, but there are some, I think, DSPs which actually kind of like try balancing it out better. And now with the US coming out with regulations, statutory caps on how there has to be a minimum amount paid for publishing and all of that, this ratio might differ. But for practical purposes, I think for you can just say that broadly it's an 80-20 split. And so which also goes back to what I told you about how your master rights are valued a lot more than your publishing rights, because most of your master rights are owned by labels and corporates. So it's more about, I think, like a dynamic, like a demand supply dynamic. And also because of lobbies owned by corporates, right? Ishan, you had a question.
Yeah. Hi, Sandhya.
Hi.
So I have a query that, let's suppose if I am a singer on any of the songs, and I'm also a composer of a song. Like, let's talk about two of the parts. That if I am a singer-songwriter for one of the song and I am just a singer for one of the songs, and
you're the singer-songwriter for one song and only a singer for the other song, you're saying. Okay.
So if I am not associated or registered with, right? So I'm not eligible to get those performing royalties, even if I'm a singer-songwriter for that song?
I actually are you saying even if you're not registered to the Copyright Society, are you saying that you will not be able to collect the royalties? Is that what your question is?
No. So my question is, like, if I'm registered to IPRS but not
Okay.
registered to ISRA, right, which is the Singers Association.
Yeah.
So I understand for a fact that in a case where I am not a composer, I'm just a singer, I'll not be getting the royalties. But in a case where I am a singer-songwriter, I'll be collecting royalties from IPRS, but will I be getting the royalties for the performance as well as a singer from IPRS in that case?
No, no. Because IPRS is, so that kind of, that I think that's a good question for me to also explain that in India, you have a copyright society which acts as performing rights organizations and collective management organizations. So they are registered copyright societies to represent rights holders in each category. For sound recordings, you have RMPL today. For IPRS, so for songwriters, which is composers, lyricists, and also publishers, representing them is IPRS. And then you have ISMRA, which is for performers, which is singers and musicians. Each of these societies collect performance royalties for each of these categories. So if you're not registered with any of them, if you are accruing royalties in your capacity as a performer or as the owner of a sound recording or as a composer, and if you're not registered accordingly, you're missing out on performance royalties from that aspect. So in your particular example, if you are a singer and songwriter, you should be registered with both IPRS and ISMR. So that way you'll be collecting performance royalties for each of those categories. Because IPRS is only collecting performance royalties on your behalf in your capacity as a composer or as a lyricist. And they also collect performance royalties for publishers. Okay. Sorry, Arun, you had a question. As a record label, okay, I'll go into that in a bit because that's the last bit of what I'm going to be talking about. Got with performance correct, yeah. Performers means performers on the master recording. So you could be an instrumentalist, you could also be a vocalist, and you are allowed to register with ISMRA. And ISMRA has a lot. So you have to also, there is a difference in being, if you're credited as a performer, ISMRA is collecting royalties based on a certain calculation if you are credited as a performer in the distribution. If you're credited as a performer only on YouTube, then the royalty that is being collected is little lesser. In the sense, the split of the collections is varied based on that. So they have a rationale behind it. So, like for example, a featured artist and a singer are given a chunk more of the performance royalties collected by ISMRA, as opposed to the people who are backing vocals or sessions musicians not credited as featured artists. Yeah, okay. Sorry, Sahana, you've had your hand up. Tell me.
Yeah, hi. Just a small question. So, how exactly are royalties distributed in India? So, my understanding about the US is that a certain X amount of money has to accrue against a particular song or against a particular publishing right before it can then be claimed by the artist. For example, if that amount is, let's say, $5, if that is accrued less than $5, even over a period of 5 months, then the artist cannot claim. Rather, it has to cross that amount and then you claim. But how does it work in India, and is it automatically disbursed, or do the artists go have to claim it, or how does that work?
Great question. So the thing is, now with each copyright society, each of them have different thresholds, and for you to be able to register with each of these copyright societies, you need to have at least one song that is published, which is crediting you either as a composer or as a performer or as someone who owns the master rights, right? And it's only after it accrues a certain value, like I said, it could be, if I'm not mistaken, I think they have like a 500 or 1,000 rupee cap. IPRS did at one point of time. I'm not sure what it is now, but that's a great question, because it's only after you hit that threshold that they actually, disburse those funds. And you need to be registered with them as like for example with IPRS, you need to be registered with them twice to be able to collect your publishing, your performance royalties that accrue to you in your capacity as a publisher as well. So I'll clarify this, because as an independent artist, you might not have a publisher. You might be working on your own. You might not really have any label that's backing you, right? So then you have to register with IPRS as a composer, as singer-songwriter, basically, as a songwriter, basically. I think the easiest example would be an indie artist who is written his own lyrics, composed his own tunes, and owns all rights. So then, if that artist will have to register with IPRS as the author, as the composer, as the lyricist, as the composer, and also register again separately as a publisher. So there is a separate process for each of these categories, because IPRS splits its collection into performance royalties that accrue to publishers and performance royalties that accrue to author composers. Performance plus mechanical royalties. But the thing is, with the problem with the threshold is that now I think there's a lot more transparency in how it's being collected, because they have like direct relationships with DSPs like Spotify and YouTube and Apple Music, which actually give them statistics of like, how many streams have accrued, so on and so forth. And IPRS has a certain method of calculating the royalties based on that data. RMPL has a separate method. ISMRA has a separate method. So, like for example, with ISMRA, if you are not a featured artist, the royalties you're collecting from them will be lesser than maybe a singer or a featured artist. So I know that there's no minimum amount. Like for example, in the US, like you mentioned, there is a minimum statutory threshold of revenues that have to be collected by these societies. We don't have that here, at least not yet. So I'm slightly convoluted answer, but I hope that answered the question. Yeah, one second. Okay. The difference between PPL and PRO. So PRO is a broad umbrella term for performing rights organizations. So all of these guys like RMPL, ISMRA, IPRS are all PROs. PPL in India is no longer a registered copyright society. It is only an authorized agent of some really large labels. They have lost their status as a registered copyright society, I think in 2017 or 2018. RMPL is the one that has now been instituted as the official registered copyright society for sound recording owners, like for master rights owners. And Madhurima, okay, how do bands collect royalties? Okay, now with bands, I'll take examples of people that I've worked with, right? Like Swaratma, Thaikudam Bridge. Both of them have registered each of their members with IPRS, and obviously they have acknowledged themselves as affiliated with Swaratma or affiliated with Thaikudam Bridge. So when the royalties are being collected, it is split equally. So these two bands, I know, split their royalties equally, but there are bands who have registered themselves as individuals and affiliating themselves with a particular band name. And while doing so, you have to submit a particular percentage that each person is entitled to. So this is what happens when you register your songs with IPRS. You have to give them your work notification form that you upload with IPRS is basically all of these details, saying that now you have one person handling it for the entire band. It makes things easier, because then you know, okay, this person gets this much, this person gets this much, this person gets this much, or it's an equal split. If you've not mentioned the split, then it is distributed equally between the people who have been listed as affiliated with this band. So as you have to give your legal name and your artist name. You can give a lot of, you might have multiple artist names. So you have to specify that with your copyright society when you are registering with them. Okay, music producers. So Madhurima, I hope that answered your question on how bands collect royalties. you have to make sure that each of the band members is registered with the Copyright Society. And you said, okay. Yeah, Kanu has mentioned author composer 25-25, publisher 50 equals 100. Yes, correct. Now the author composer split can be contractually agreed upon, right? So there are instances where even but the publisher split will remain 50% because that's like the minimum threshold. So it's 50, 25, 25 by default. So if you have not mentioned the split, then the default split is 50, 25, 25. If you have mentioned the split, then it remains 50. And the 25, 25 can be a 30, 20 or a 40, 10 as well. That has happened in the past. And that is something which you can do when you're submitting your work notification form. Music producers on royalties, again, I think right now, based on industry standards or industry practices, it doesn't go by default, right? It all boils down to who is being credited as the songwriter. Now, if your producer is asking for songwriting credits, so basically being acknowledged as a composer or as, when you're distributing the songs, that automatically is implying that they are asking for publishing rights. On the other hand, there are contractual arrangements that you can enter into where you get points on the masters, and you kind of like say that I have like a 15% on masters and I get like a 15% on publishing, and I also get songwriting credits, right? So songwriting credits means they can actually register with IPRS and collect performance royalties on that. And they are also entitled to like sync royalties in that percentage that you've agreed to. So there is no statutory default for producers. It all depends on what their role is in the composition. So I might be someone, as an artist, I have my entire track ready, but I just want someone to come in and kind of like put everything in its place and not really adding more than what I have already worked on, or whatever they are adding is based on my instructions. So then I think that based on the degree of involvement, you can kind of negotiate what your songwriting credits would be like, or what your cut in publishing or masters would be like, as opposed to someone who you have approached and you say that I have this track and I want you to like just make magic out of it, and that producer kind of adds so much more value, right? So therefore there you have there is a legitimate cause or legitimate I think right to publishing rights basically. So there is, unlike the US, where again you're not really looking at it over here from that angle where there is a statutory requirement to provide the producer with songwriting credit. And you also have to keep in mind that how our Indian industry has evolved is very different from how it is in the US, because historically we've had such a I think ownership of music has worked very differently here, because most of the music that was created for the film industry, and by default all ownership vested with production companies or with record labels. The whole concept of the composer or the lyricist or the performer retaining any right in it is very, very new. And in fact, the concept of sync licensing also is very, very new as a result. So unlike the US or in Hollywood, where everything, like the film industry, didn't have its own subset of a music industry within it. It was only about licensing music from outside. So how we approach copyright law in India has evolved and changed a lot. And now I think we're kind of catching up with the practices from the West. Wait, sorry, there's a bunch of new questions over here. Actually, so Pratika, with respect to advertising, now advertising, it again depends on what the usage is like. If your song is being used only as a jingle, where the jingle is attached to a video, or it is not being monetized as is. So say, I'll take two examples, right? You have one which is a anthem which you have made for a brand, which appears only as an ad. So you're not that anthem is not available on Spotify or anywhere else. It is only something which you see as an ad or hear as an ad on radio. In those instances, the song as is not being monetized. So you're not really looking at any royalties accruing from it. So there's no performance royalties, there's no mechanical royalties, nothing. And those kind of works, specifically those kind of works, will be treated as commissioned works. So apart from being credited for it, there is nothing else that you're really getting out of it. So, but if you look at more often than not, when you enter into a contract for these kind of things, you should be negotiating and making sure that it is the usage of that track is either for a limited period of time or for a particular territory, and that if they plan to remake it in some other language, or they plan to have that song played with the ad in some other country, then you should be compensated, and you should be additionally compensated for that. So what you're talking about, the time frame of usage and all of that, is very important when you're having that discussion. And now, on the other hand, if this is an anthem which they also want to be distributed on a Spotify or on a YouTube or whatever, or available to actually listen as a separate video and not as an ad on YouTube, or actually to be available on Spotify or on Apple Music as a song, then there is a very different conversation to be had there. There you have to make sure that you are credited as a songwriter, as a performer. So then you're able to collect royalties on performance and mechanical from your respective copyright society. I doubt you'd be able to ask for any master rights in it, because this is going to be owned by a brand. But you can push back and say that you are entitled to retain 50% of publishing, and that if they choose to do anything with it at a later point of time, they still need to come back to you, right? So that is on the advertising link. Okay. So publishing, I think from an American and Indian perspective, publishing is the same, right? It's your underlying works. The reference to underlying works is what publishing is. And there is no songwriter is a combined term which is referred to someone who is a composer / lyricist. So they refer to a songwriter for someone who is not just writing lyrics but also writing the melody. It's a universal term. But it's not a commonly used term in India. Here we either refer to them as author or composer or lyricist. Those are very specific categories. So I don't think songwriter is a usage that is very common within the industry. But so the difference between a songwriter and a composer is that a songwriter could also include a lyricist, whereas a composer is only a composer. So yeah. I didn't understand this, Madhurima. So MP could be like a work from home arrangement, sorry. Oh, work for hire, sorry, WFH is my bad. Oh, music producer could be like, yeah, it could be like that as well, yes. So actually a great example of work for hire, and this is something I think Sahana and I, we discussed this on Instagram, on LinkedIn as well. The work for hire arrangement is a great example would be like the relationship between a programmer and a composer, right? You have a lot of big industry film composers, music composers who have programmers who work for them. And without taking names, a lot of them do have programmers who actually compose entire songs, and it's the composer who basically adds the finish, the final touches, and it kind of goes out in the composer's name. But the programmer is not getting credit as the songwriter or as a composer. And it's almost like ghostwriting to that extent, right? So in those instances, I would say that it's a work for hire. It's a true work for hire, because you have been hired by this composer to do everything based on their bidding, and you're being paid for a certain amount for it, and whatever you do is submitted to the composer as a consequence of your employment with him, and therefore he owns everything that you have created under his instruction. And that is what a real work for hire is. So like referring to work for hire in with record labels or with a music director and a production house is not accurate, because if you're being credited for something, and if your name is going to show up as the composer or as a lyricist or as a performer, it stops being a work for hire. So yeah, okay. Independent singer, can I put my own name as a label? If I've kept the distributor's name as label, then do my... Okay, so now it depends on what your contract with the distributor is. So just because the distributor is, when you're saying distributor is named as a label, where is it being named as a label? What is your contractual arrangement with them? If your arrangement with them is only an exclusive license, then it doesn't mean that they are the owner, because they just have a license to use it. They still don't own the rights. So showing yourself as a label is fine. I mean, it depends on how you, where you're crediting yourself as a label or calling yourself as a label, right? As far as I'm concerned, as an independent singer-songwriter or independent artist, you are everything. You are your own label, you are your publisher, and you are the singer-songwriter as well. So it's the easiest example to take when we're talking about copyrights, because there's only one entity who owns all these things. Keeping in the, okay, during distribution. So yeah, so I think that's the C line, P line basically. So you will have, each distributor has different kind of methods to kind of show who owns the master sound recording rights and who owns the publishing rights. And I think DistroKid has like these random numbers. I think TuneCore has its own name, but that doesn't mean that they own the rights. They are just doing, this is only for the purpose of logistics, to show that I am collecting these royalties on behalf of this person, and I have the right to call myself this because they have given me an exclusive license to do so and so things based on the terms and conditions they have agreed with me when they have signed up on this platform. That doesn't mean they own it. Ownership will happen only if you pass on all your rights to that person. And they're like, you sign a deed of assignment to say that I'm giving all my rights to you. A license is only the permission to use all of this for a particular purpose or for a particular period of time. Cool. Great. Hash, okay. And the composer, yeah. So now if you're the composer of the song and you're also the singer, you're collecting different kinds of royalties. You're collecting performance royalties from two separate societies. I'm talking about performance royalties, right? So if that's your question, I mean, because there are other implications of this as well. Because for example, if you're doing this in, say you're hired by a production company for a film to do the soundtrack for a film, and you're also singing and you're also composing, the question that I also get asked is, can I charge an additional amount for my services as a performer as well? And the answer is yes, absolutely. Because A, you're being hired as a music composer to compose certain songs. You can offer a combined package as well, but I would always recommend that you budget it like this. You can say that I'm spending X number of hours for composing the soundtrack. I'm also going to be spending X number of hours as the performer. So you could be an instrumentalist, you could be a vocalist on your own soundtrack, no problem. But use all of those hours to like kind of calculate and say that, okay, this is how much I will charge for a particular project. But from a royalties perspective, you are collecting royalties from these two copyright societies. You're collecting it from ISMRA and you're collecting it from IPRS in your capacity as composer in one and singer in the other. Singer / actually for that matter, even as an instrumentalist. So you might be a singer and an instrumentalist. You should register with ISMRA as both. And basically now I think they've kind of combined the process. You can indicate that you are an instrumentalist as well as a vocalist, and you can actually give like list out the songs that you have performed in, meaning sung and played in, and kind of like identify those accordingly. Okay. Yeah, Abhilash.
Hi, Sandhya.
Hi.
Hi. So, like, I have a couple of questions. One thing is, I'm rock solid on the, production of music and,
Mm.
getting it out. I have the whole thing already. So, what I'm thinking about is, since I'm actually making the music and, I want to feature an artist from outside, and they'll be just singing. They're not contributing anything in any way. So, I have the whole, procedure ready. But I want
Mm.
to ask, I have to register myself as an member of IPRS and then go ahead about actually featuring an artist on this and just asking them to sing on this? Or do I need the artist also to be registered on IPRS?
No, you don't need the artist to be registered on IPRS for sure. Because, and
Okay.
honestly, it's not your responsibility. You can inform them, but they need to
Okay.
be registering on their own so that they can collect royalties from that copyright society. It's not your responsibility to collect royalties on behalf of anyone. Because in
Okay.
India, copyright societies collect and pay out royalties only to the individual concerned,
Okay.
or unless you're registered as a publisher. So if you have a featured artist, you just have to like get them to sing their song and pay them their fees, and that's it.
Okay.
And you can, like I said, I mean, you can inform them that if they want to see performance royalties from that particular track, they can register with ISMRA.
Okay. As far as I'm aware, I know that once I make music by like from myself,
Yeah,
I own the publishing rights, right? I don't have to get it documented unless and until it is like a contract with any other label or something, right?
exactly. Correct. That's
Yeah.
absolutely right.
Yeah.
So, I
So
mean, that's what they call it, the poor man's copyright, right? Like if you've composed, you have like a scratch, you email it to yourself because it might be lying
okay.
on your hard drive, but it's not
Correct.
published anywhere. No?
Mhm.
So people upload it as private links on SoundCloud to show that, okay, this is existed on a publicly available platform. It might not be available for public viewing, but these are all like methods of showing that, listen, I've done this first. Like
Correct.
I've had this ready first.
So as this whole thing is about actually like becoming a music label. Like, is it just a work in progress kind of a thing? So do I need to just make music and put it out and get registered on IPRS, or is it like for label to start putting music on Spotify and Wink? Does it have to be a registered uh, company or something?
No, 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 no. So there's no process over here to become a record label. You just need to be an entity. In the sense, um, if you want to have your own label, I would say you can register yourself as a limited liability partnership with someone you trust, with a family member or someone who you actually want to do business with, or you can register yourself as a sole proprietorship as well. But it's just that you will have revenue coming in on the same PAN card. I mean, it's a very different. It's not related to copyright. It's more on like tax and compliance. So speak to a chartered accountant about it and get that sorted. Like if you're looking at setting up yourself as your own label, if you want to basically have a separate identity for someone who owns the master rights, you can do that. I would always say go ahead and just incorporate an LLP. It's not a very difficult process. And you can keep that separate. You can say that everything, all production work and all of that can be routed through this, and that entity owns all the masters. And you, on your own, in your individual capacity, you own your publishing right.
Okay. Thank you so much.
No problem. Cool. Okay, does anybody have any other questions? I've kind of like pretty much covered everything that I wanted to talk about through all the questions that each of you have had. But and I know that we're like at the last like 10 minutes of our session, but there are a few things I think which are extremely important for you as artists when you are negotiating contracts. So, as an artist, as a songwriter, as a singer, as a musician, as a music producer, right? You are going to have different kinds of contracts that will come your way. One will be, I think the most common one would be like, yeah, like something which everybody is anticipating or wants to, execute at some point of time is something with a label. Um, you have your record label deals, you have collaboration agreements. That is basically, if you are writing a song with somebody, or if you are composing a song with somebody, if that's a collaboration deal, then have something in writing, please. And this is what you refer to as a split sheet. So as a band, and these things go wrong more often than not. As in, even the best of friends, the closest two people can fall apart. And at that point of time, you're fighting over a song. You don't want that conversation to be had when you're not in the right frame of mind. And I've seen these conversations go really ugly. So I would recommend that if you are, whether you're a band, whether you're a duo or a trio, if you're collaborating with someone, please get things in writing. The more elaborate, the better. It does not have to be a very full length kind of like complicated legal contract. It can be a one pager saying that we are working on this particular song. We will split the royalties that we get on this in this particular way. At any point of time, if there's any revenue that comes in from the song from sync licensing, it will be split in this particular way. All of those things can be agreed to in writing. And with record labels, with production companies, that is record labels, if you are working with them as an artist, when they're signing you on to do an album or an EP, do not agree to album cycles. Do not agree to 3 albums, because that could mean 25 years of your life, or maybe 3 years. You never know, right? It's always better to have a capped number of years, have like a 3-year or a 5-year cycle, and push back on 100% assignment of rights, because it is not legal. Having them retain 100% of master rights is one thing. I'm not saying it's the best case scenario. Your best case scenario is that you get at least 50% of all rights, 50% of masters, 50% of publishing. Worst case is that you give 100% of masters and retain at least 50% of publishing. So the other things which you need to also keep in mind when you're dealing with a label is that, especially if they're also offering artist management services, a 360-degree kind of deal, transparency. Make sure that there is an obligation on them to provide you with regular updates and reports and a projection of expenses that they intend to spend on your record. Make sure that there is some kind of a commitment to review these numbers, either every quarter or every 6 months, so that there is some kind of accountability that you are requesting and requiring from them, and that it's contractually there as well. And I'm not saying steer clear if they don't agree to it, but it's a red flag. It's a huge red flag if they say that they're not willing to do it, because I think and the dynamic is also very different when you have approached a label versus a label approaching you. So all of these things need to be kept in mind when you're negotiating a contract with a label. But ideally, get a lawyer, and ideally, preferably a lawyer who has context and understanding of the music industry, because I have seen lawyers without context actually, doing more damage than good for the client. So that's another thing for you to keep in mind. Okay. Before I go on to the next contract, let me just quickly check what this is. Arun, yeah, I think we're going into that the kind of contract, so we'll discuss that. But I think Chetan has there's no registered label or distributor. Okay. When you say you collect regional songs from your region, what do you mean by that? Chetan, would you mind clarifying? Because I want to understand what that means a little better, so that I can respond to your question appropriately.
Yeah, actually, in my region, from Darjeeling, people actually don't have a proper label to whom we can distribute songs, right? So they are individual artists making their songs and only, releasing to YouTube. Okay, and recently I've started collecting all these songs at least, and then taking help from Horus Music to distribute it to Spotify. I mean, all the DSPs. Now,
when publishing rights comes into play, how do I go about? I mean, as a collector, I don't say myself as a label, but how can I help them reach more people, or help them earn more as an artist, right?
Okay, so this is, I think, it also depends. What is your relationship with each of these artists, right? They've not assigned the rights to you. Technically, you're just acting as an agent for them, as an
Yeah,
not even like an authorized agent. It's not like you have any contract with each of these artists, right? So you are
nothing,
just
nothing.
basically helping them out, saying that, "Acha, listen, your song is only there on YouTube, so let me just help you out and get you onto these other platforms as well." But when they're being credited in those songs, whose name comes there? Their names
My
when you're
name,
distributing. Oh, your name.
yeah, that's what.
So you are being credited as the artist for these songs?
No, 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 no. I am myself. I'm showing as a label, but artist and all those things are specific names. I mean, whoever is artist or the composer, I give their name. My name
Okay.
comes only as a label.
Okay, so in that C line, P line, it will probably come. So you
Yeah,
kind of
yeah, yeah.
put yourself. Okay, got it. So then,
Correct.
and see, there is, like I said, there's no registration process, right? So you've kind of already made yourself like a label kind of entity.
Yeah, yeah.
So though technically, I mean, an individual being a label is like having an independent artist who owns all their rights.
Yeah.
So here,
Yeah.
the only trouble over here is that without having a contract between yourself and the artist, this could become like a legal issue later on if any of the artists decide to like pull the song down, or if there is, or I don't know, like tomorrow if there is a claim that one of those artists has like in plagiarized the song, it can come onto you. So I'm saying you need to kind of like put all of this, either like identify yourself as an agent and don't put your name as the label, because you don't technically own any rights. They've not assigned anything to you. They have just reached out to you to like put all of these songs onto these platforms. So unless you have some kind of written acknowledgement from them saying that, yeah, I'm actually giving you these rights and you own these rights, or just authorizing you to do it, those are two very different kind of situations. So you should, I would think, if you're looking,
yeah. And they are also ready to sign a proper contract with me actually. But in our region, what happens is that they are also ready to do it for me. So what I do, I mean, I take I have a proper contract in place with them. You do better, right?
Yeah, of course. And I think like I said, it doesn't have to be a very complicated contract. It can be very clear in terms of, now how you want to position yourself as a label or as a publisher is also something that I'd leave to you, because a publisher is someone who does not own master rights. They are just saying that I have all of these songs on with me, and I own 50% of the publishing. Basically, they have assigned, the artist has given me the rights to do it, and I am pushing these songs and these catalogs to do more. Actually, Horus acts as a publisher. Horus has its publishing wing. So I would actually think you're probably like, if you're positioning yourself as a label, then you say that, okay, I'm doing this on behalf of the artist and I own the master rights, or I own 50% of the publishing, and whatever revenues come will be split according to that.
Okay.
We probably have to discuss this a little more, because it's given, I think, how because right now it's kind of like casual, right? Like this whole arrangement is very like you're helping them. Yeah, so I think for you to like kind of make it a little more organized and structured, you'll have to, I would recommend that you set up like an LLP and say that this LLP will act as this particular, everything goes through that entity, and that LLP will enter into an agreement with each of these artists, and you can basically act as their authorized agent or label, and you're also contracting with Horus to like get the distribution out, and also like manage publishing rights for them and all of that.
And what if they are not registered with IPRS?
Then you should get them registered with IPRS.
Okay, only then they will be.
Yeah, and in fact, you should that LLP should register itself with IPRS as a publisher.
Okay.
So then 50% of the performance royalties and mechanical royalties will come to this entity as a publisher, and you can, if you're choosing to like distribute that further to the artist, you can do that. But they will still need to register the IPRS for them to be able to collect the other 50%.
Okay, got it.
Okay, I think Lakshmi had a question. So any Indian artist who sings a song with instrumental music which already exists in any film. Okay, so basically these are covers. So what you're talking about is now covers, I think, are a great example of how technically you need licenses for official covers. Like if you intend to put out a cover and monetize it, like ideally covers on Spotify or Apple Music, and for that matter, even YouTube. Ideally, if you want to make money off those covers, you need to actually get a license from the person who owns the publishing. Because you are basically rendering the composition and the lyrics as is, right? You're not really like adding anything new. Like it's not, you're not creating a new piece of work. You're just covering the song. And, but you don't really see, so if you see like millions and billions of covers on YouTube and SoundCloud and all of these without any license, because that's the platform kind of enters into like an arrangement with the labels or the publishers who actually own those rights to kind of let that happen. And you don't have to pay anyone for it, but you're not going to make any money off it either. If you want to make money off that cover, then you need to get a license from the publisher. And yeah, regardless of whether you're registered with IPRS or not, you're not going to be making money out of it. But that said, I do want to clarify that, and it's not a legal practice. I mean, I know that a lot of the streaming platforms face that issue where they have unauthorized covers which are being uploaded for distribution, and they are kind of like working on. There's like a constant, churn of takedown requests that come from labels or depending on how popular a particular cover gets. But there are so many that kind of like fly under the radar. Yeah. Yash, sync licensing platform, there are a couple of them being built, to be honest. So it's not, it's kind of, I feel like it's a tough market because there is no one price fits all kind of arrangement. So as of now, I think the best arrangement has been that, you have a music supervisor working with a publisher, and there is like an active sync licensing pipeline that goes on there. But if you are willing to like invest in a lot of tech and kind of, popularize the whole concept of making sync licensing as easy of like going and shopping on Flipkart or something like that, then it is something that you can look at. But like I said, there are platforms that are still being built. I think Fairplay is one which is actually targeting sync licensing on a large scale, and they're going like high tech for it. So yeah, that's my answer to the question. Difference between a publisher and a label. Okay, a label can also double up as a publisher. A publisher basically is someone who basically owns publishing rights. So you enter into an agreement with the publisher to give a percentage of your publishing rights only. They have nothing to do with the masters. So they are kind of people who basically try to make your song do a lot more work. And they'll see if you can get more collaborations to create more music. They'll look at, licensing your songs out for sync. Those are the kind of things that a publisher does. But more often than not, most of the large labels have their own publishing subsidiary. So most labels also double up as a publisher. Yeah. Okay, great. All right. I think we're kind of like out of time, but thank you. I know there's a lot of questions. This is a topic that I can keep talking about like all day. But I'm very active on Instagram. And if it helps, tomorrow, it's World Music Day. 2 p.m. I'm planning to do an AMA from, I think, 2 p.m. to 4 p.m. I'm not sure. Wait. Yeah. From 2 p.m. to 3 p.m. I'm going to be doing an AMA live on Instagram. But I will be dropping a question box in the morning. So you can share your questions with me on Instagram, and I'll like take those questions up as well. So you can look me up on Instagram. My handle is Sandhya.Surendran. And I hope you found today's session useful. If nothing else, I know if it gets us to like ask more questions and read up more, I think it's a win-win for everyone. So thank you so much for like taking out time to attend the session. And thank you, Rohin and the team for having me here. I hope all of you found it useful.
Thank you, Sandhya, for taking the time. I feel the session was truly informative. We've been doing this masterclass for a week now, and we've never seen so many questions populate in the chat box. So I feel you've added a lot of value to these artists, and we will be reaching out to these artists and doing like a summary of the session in our WhatsApp group. And also we can send you the list of participants today, so if they want to get in touch with you, that will just make things much more easier. Once again, thank you so much, and thank you guys for making this so much more interactive and fun. I hope if you had some value through this masterclass, please share the Artist Alive WhatsApp group with your artist friends, so we can empower the indie musicians and give them all the tools to be successful.
Thanks everyone. Have a great evening. Bye.
Thank you. Bye.